Thanks, Ken. Take it away.
All right, thank you, Martha. As Martha said, I teach a one-day class for the last 30 years or so on the whole subject of tort liability and risk management. This is kind of a 1 hour abstract of some of the major content in that. I'm an engineer. My bachelor's back in 1970, so been around a while in the general area of traffic and safety. But one area that I've done a lot of work in has to do with tort liability, and that's the reason why I'm not a lawyer, but I've worked both through the UK, and also I've had a private business for about 40 years where I've investigated, reconstructed a few thousand cases, and testified hundreds of times. So from that background, I know enough to be dangerous as far as legal aspects. But we're going to just touch on some basic concepts you need to understand related to tort liability and risk management. Now, I see from the list today, we have a good wide range of people from the state, the city, the county, and also private industry. So I think it'll be a little bit for everybody. Again, the subject, we're talking about tort liability. These are civil cases, not criminal cases. We're talking about liability. And everybody's liable for everything you do. So, and the one thing great or horrible, I guess, which way you look at it, about the United States, is you can sue anybody anytime for anything. And we're always liable for everything that we do out there. So hopefully what we're doing is proper. And we aren't found negligent, because that's the whole issue here when I get in these cases. And I've got several cases going on right now where I'm defending the state and some contractors. We got one where I'm defending the county on various aspects of roadway design, drainage issue, at a case where a small bridge got flooded. I mean, a lot of bad accidents have occurred. The question is, was the state, the county, or whatever, or the contractor, or were they negligent? And here's the definition of negligence is did you fail as a government agency or as a contractor to use here's the big word, standard of care that a reasonably prudent person would. So a couple of important parts of this definition. One is, what is the standard of care? We'll talk about that in more detail. And what is reasonable? Reasonable seems like a real subjective word. Lawyers, love to use that word. What, did you do something reasonable or not? I'm an expert witness. I'll come in if I'm the defense of a government agency. I will say, well, you adhere to the quote standard of care, and what you did was quote reasonable. And there are plenty of experts going to say the other opposite. So we need to be able to prove and understand what the standard of care is, and show that we did meet that standard of care. So the general parts of a negligence suit, whether it's you as a government employee or a private individual gets sued, one is they're saying you have a duty, and we really don't argue about that. You have a duty for everything you do. We design a road, we have a duty to design it according to our design standards. If we put signs up, you have a duty to put those signs up properly. I should turn the phone off. So we don't argue that. The next thing is, though, did you breach that duty? That's the question. You have a duty. Did you not fulfill that duty? Then they have to prove that if you did breach a quote duty, did that actually cause the injury? For example, we might have a shoulder drop off, and somebody's run off the road where there is a shoulder drop off onto a tree. Did that shoulder drop off actually contribute to the accident, or was it just there? So that's a big issue we have as far as that part goes. I was just involved in a very huge award dealing with what was perceived as shoulder drop off in a case where there was supposed to be a safety edge installed at this particular resurfacing project, and it wasn't. But in my opinion, if you look at the sequence of events in this accident, that lack of a shoulder safety edge actually didn't contribute to the accident. So they have to prove point A leads to point B. And finally, then we also talk about what the plaintiff did wrong. So, because we'll talk about later, Kentucky has what's called pure comparative negligence. So we look at the fault of everybody. So we if you're defending a case, if the plaintiff did anything wrong, you want to show that. So that percentage, we got 100% fault. We have to divide it up between the defendant and the plaintiff. How much percentage can you say fault of the plaintiff? And finally, there's got to be an injury. And I don't get involved that too much. I'd have some. I mean, I'll say that Kentucky allows what's called a seatbelt defense. I get in some cases where my person I'm working for is completely at fault, but the injury that was sustained by the plaintiff can be related to his failure to wear a seatbelt. So a jury can come back and reduce the award by some percentage. It varies according to where you're at in the state. Some percentage because they weren't wearing a seatbelt. The other aspect we get in here, I've been in cases where you're at a traffic signal and the light turns green, somebody takes off and then they stop, and the person behind them just bumps them in the back. And I've looked at bumpers and they've been hit, and you couldn't even see a scratch on that bumper. But according to the plaintiff, he's permanently disabled. So they would get into what change in velocity that they sustained and whether or not that should actually cause an injury. So that's something to get into sometimes. So again, I've mentioned before, negligence is failure to adhere to the quote standard of care. And what is the standard of care? And there's a big long list of guidelines, standard drawings. Probably the best example is dealing with traffic signs is the manual and uniform traffic control devices. So those are all your quote standard of care. So the example I'll give with the MUTCD is it's got shalls, shoulds, and mays. So it says if you shall do something and you don't do it, you better document why you didn't adhere to it. The may conditions, that's discretionary. We'll talk about that in a minute with the difference between ministerial and discretionary duties. And then it says should, and that's open to debate what that means. But I guess the issue we get in here with the standard of care is when we start drawing up our guidelines, sometimes we put ourselves in a situation that we're creating a standard of care that we don't necessarily meet. I know I got a case right now, a Board of Claims case, where this slow moving equipment was being driven down a road at night, a fairly high volume road. Wasn't at 2 o'clock in the morning, wasn't much volume, because they were going out to address a tree that had fallen down. But anyway, he was driving down this road and got hit by somebody the download showed going 90-something miles an hour, twice the legal limit on their phone. Big problems. Why they run into their equipment. But the issue was whether or not they had an escort vehicle. And you look at the standard of care, what does our standard of care say about a requirement to use an escort vehicle? So if we say we're going to use it, better you do it. If we don't do it, we got to explain why. So that's what we get into. We start writing up our directives or what we're going to do is make sure that when we say we're going to do something, it's actually reasonable to do that. So I'll just mention that related to standard of care, because that's got us into a lot of trouble over the years. Kentucky is one of the few states in the country that still has sovereign immunity. And what that means is, it goes back to England when the king's sovereign. I guess in Kentucky, the governor's sovereign, or we have a lot of debate over that now, don't we? What powers the governor has versus the legislature, but that's a whole nother case. But the issue about sovereign immunity is Kentucky has sovereign immunity. So it means that on a state maintained road, if you have an accident on that road and you think that the state did something wrong, you can only get the amount of money that's allocated or approved or through what's called Board of Claims. So that's the way you go through as far as suing the state. We'll talk about that in just a minute. Well, right now, again, Kentucky has sovereign immunity. So if you want to sue the state on a state maintained road, The only way you can sue the state is through Board of Claims. And it's a limit of $250,000. And the minimum claim is $250. So in the last time it was changed in 2017. So it was raised so that the limit you have is $250,000 for a person or $400,000 for everybody involved. I will say here, you can't contract away liability to the contractor. It becomes a big debate. What I see a lot, I do a lot of work in where the accident occurred in a construction zone, for example, or even afterwards, after the contractor has finished a job, they'll sue the contractor and the state. The deepest pocket's the contractor. And when they start suing the contractor's major defense is I just did what the state told me to do. There's the contract. I fulfilled the contract. The state inspected the contract. They were out there every day looking at what I did. And after it was all over with, they approved the contract. We get into this a lot. So the question is, the contractor points their finger at the state. The state says, no, it's not us. It's your duty as the contractor to fulfill that contract. And it's interesting. Judges seem to come down on both sides of that from one time to the other. But that's a big issue that we get into over and over. Another thing with Board of Claims is that you're only allowed to, as far as an award, has to be actual documented expenses. You can't get an award for pain and suffering, for example. In some cases, that might be the biggest award. I had a deposition yesterday on a large claim involving well, we'll get into details about it, but the guy I was talking to afterwards about the case, which could have involved the state. When I get in these cases, this is a plaintiff case. I said, I can't get involved. It's going to be a case against the state. But his point to me was, and what I see a good bit of is, as far as against the state, he said, I don't do that anymore because it's just not cost effective. Because the award that you can get, again, I mentioned before, the maximum amount you get is $250,000 per person. So if you got one person injured, that's your maximum amount. And you have offsets that come off of that. If they get so much various types of insurance, it's always confusing to me what the offsets are, but they can cut that back down. And on top of that, you can't get any of this pain and suffering, mental distress, and all that. So they typically won't go against the state unless that's the only pocket they got, or they just want to throw that in as an afterthought, because that's not the deep pocket, and that's where plaintiffs lawyers go. They go for where the money is, and it's not typically it's not the state. Now we have three different kinds of roads out there. We have, as far as maintenance, we have the state maintained, we've got the county maintained, we've got the city municipal roads. So as I talked about from the county standpoint, from the state standpoint, the state has sovereign immunity, but you still can sue the state through Board of Claims. One thing I should mention about that is that given the fact that the Board of Claims has this limited amount of money they can get, people start looking, where else can I go? That is, plaintiff lawyers will. So the other place to go is individual people. So I'm seeing more individual state employees being sued. Because sovereign immunity is a great thing for the state of Kentucky government-wise. It's not a very good thing employee-wise, especially for counties. Counties are the next type of road I'll talk about. On county roads, the county is considered an arm of the state. And again, this is my opinion. I've seen it done over and over again. I'm not the lawyer, but this is my understanding of it, and I think it's correct. The counties are considered an arm of the state, so therefore they have sovereign immunity, just like the state does. But there is no Board of Claims for county roads. So if you have an accident on a county road, say a stop sign is obscured or a stop sign is down, been down for a while, somebody runs through that intersection, we got a serious accident, they could try to sue the county, and the county is going to say, I got sovereign immunity, just go away. Basically, is what they say. So therefore, where you're going to go, and where they do go, there is individual people. And they'll sue the county judge executive, county magistrates, county road foreman, county engineer, if there is one, and on down the list. And the case I mentioned before, the case down in South Central Kentucky, where we had water over a low ford bridge, and the water got over the bridge. This girl went across the bridge, washed off the bridge, fatal, horrible case, fatal crash. And they're suing all kinds of individual people in that county, in addition to the people, the contractor who designed the bridge, the contractor who built the bridge, everybody involved. Now, cities are
Hold on,
not.
Ken. Ken, you
Go
got a
ahead.
question? Does qualified immunity attach to the employee?
If what you're doing, and we'll get to that in a minute, if what you're
Okay.
doing is
Okay.
ministerial versus discretionary, we'll talk about those duties in a minute.
Okay.
Now, municipalities are not considered an arm of the state, so they do not have sovereign immunity. So it's just how much, if you sue, if you're at an accident where it's a city municipal controlled road, you can just sue them for how much damages you got. And most of the cities have insurance through League of Cities. Now, counties still have insurance through CACO, Kentucky county organization, so they have insurance that way. But some cities have insurance for private companies. I've worked with a couple of cities where they got sued and they were self-insured, which I didn't think was necessarily a very good idea, but that's what they were. If you look at claims, I could summarize. I'm going to show a little bit about the type of claims we're having. Again, these claims are, information I get here is through board of claims, because I don't have summaries of counties and cities type of claims against them, but it's the same kind of deal. A couple of important points here. For this several decades of where the state was sued, where I summarized the information, a couple of numbers off of here. One is that 48% is the percent of a claim that there was some kind of payment. We have a lot of claims where they sue for $250,000 and they end up paying them $2,000. Just, this is a nuisance value. The important number is that number on the bottom, 15%. That is the percent paid of what's been decided of all of the money that was sued for. That's saying that, that we're only paying out 15% of what people are suing the state for, which is a pretty low percentage. So plenty of lawyers who know exactly what's going on know two things, or a couple big things. One is the amount of money you can get from suing the state is not very high because of the sovereign immunity and the limited amount of exposure there. The other one is that they haven't had a whole lot of luck of getting large awards. So as a result of both of those, if you look at the amount claimed over the last many years, it's not like you think lawsuits just exponentially go up over the last few decades. It really hasn't. It's kind of jumping around. Back in the 80s, it's a lot lower because back when I started first doing this, which is back in the early 80s, the maximum you could get on any claim was $50,000. Then it went to, for a person, then it went to $100,000, then it went to $200,000. Now it's $250,000. But if you look at it from the 90s on through now, 2011 is the last data we had summarized, it's just jumped up and down, and that's still the case now. I still work on board of claims cases, and the amount of cases I work on, it certainly hadn't been going up in the last few years, and they might be going down because there's just not a huge number of cases out there because of sovereign immunity, and it's not a cost-effective thing for plenty of lawyers to spend their time on in general. If you look at our number of cases, over half our cases are under $500, but only the big ones, $50,000 or more, only represent about 6%, because the big cases are like so the minute potholes. If you look at the percent paid versus how much was claimed, it's an interesting little graph. I think is you'll see that for the small cases under $500, about half of the amount claimed is actually paid. You get up to a big cases, 50,000 or more, 12% of how much are claimed are actually paid. So a lot more defense work goes into those big cases for sure. And what are our little cases? Pothole damage vehicle. That's our big one. Thousands of cases. So if anybody has a run over a pothole out in the road and bust a tire, bust a rim, get online, get your board of claims form and turn it in. That's what people do all the time. And they get about half of what they're sued for, they get for potholes. That isn't where all the money is, though. The reasons for the highest claims and the reason for the highest amount paid, forever, it's been the number one reason has to do with signs and markings and signals, signs and markings, dealing with MUTCD. Lack of a stop sign being down, a lot of cases involving curve signs, object markers or lack of object markers, that type of thing. The second one there, which is number two as far as claimed and number two as far as amount paid, has to do with drainage issues. And that is an issue with either getting water off the road or the ditch clogging up and water getting over the road. I could talk forever on various cases that got go, but I got one right now on the interstate, major interstate, real high volume interstate. We're with a big, huge contract where the state increased the number of lanes change it from a 4-lane interstate to a 6-lane interstate, and change it from a depressed grass median to a median barrier. So now, though, when they did that, now you have to get the water off the road. So we've had a certain section of it where after this was built and finished, our number of wet weather and hydroplane crashes just increased dramatically, several 100%. And it wasn't because of any negligent design, in my opinion. It was because we had a situation where water was coming down a grade, it was a long hill and around a curve, and we've increased the width of pavement, and water just has to get off the road. So it's a drainage issue, you could say, but is it a negligence? And we're in the middle of this right now. It's had a 5-hour deposition on it not too long ago. Because they're alleging negligence in the design, but I'm saying, no, it isn't. You have to get the water off the road. They did not violate the quote standard of care, but that's what you get into in these cases. An example, here's one of dealing with signs. Where's our stop sign at? Well, it's on the opposite side of the T intersection, which is where it cannot be. It's not supposed to be. We have a lot of that situations. You probably don't have to go very far to find situations for T intersections where our stop sign is on the opposite side of the intersection. We have violated a shall condition as far as the MUTCD goes. If somebody has an accident here because they didn't stop, they'll say, I didn't see the stop sign where it's supposed to be. In fact, the manual says it shall be on the right side of the road before the intersection. It can be up to 50 feet from the intersection. So we violated a shall condition. So we got big problems. Now, why is it there in this situation? Well, there's a problem with putting it over the right side of the road because of, you can see all that house over there and whatever. So what's our options? I've run into this variations of this several times where what can you put on the other side of the road? Well, you can put a double arrow on the other side of the road. You can put your stop sign on the left side of the road here. You can put a stop bar. If you cannot put one, if there's absolutely nowhere to put one on the right side of the road, document and say there was no place to put it there. So we put stop ahead signs. We put a stop sign on the left side of the road. We put a stop bar on the road. We put a double arrow on the opposite side of the road. So what the point I want to make here is, and I'll try to make it more than once, is you can deviate from what I would call the quote standard of care. If that word comes in again, reasonable, if you have a reasonable documented reason to do it. We're going to debate what's reasonable or not. Again, that's a subjective word. But what I've seen a lot is that we didn't do something And after the fact, we say, well, this is why we didn't do it, but we didn't document it at the time. So I can't emphasize enough how important documentation is, especially if you deviate from the quote standard of care that you usually use. Well, here is a example of a drainage problem in the southeastern part of the state. In this case, where you can see where's this water coming from? Well, it's coming down from this private driveway across the road, and then obviously we got some major hydrant water pooling, don't we? There's another. So we come around, this car comes around this curve, it's this major pooling of water, and hydroplanes end up in the other lane. We have a head-on collision. So how are you going to defend this one? Yeah. Good luck trying to defend this one. Sometimes, again, we only pay 15% of the amount claimed. Sometimes it's just the way it is, and you just say settle this one. So what the question is in this case? What are you going to do? The one thing in this slide, you can see water is just after it goes on the road, it stays on the road because our turf shoulder is higher than the surface roadway adjacent pavement. So we could, if we came through there and knocked and graded down the shoulder, that we at least we get the water off the road after it gets there. But we like to keep the water from getting on the road to start with. So we got a problem with our drainage here, with our ditch being clogged up. Water is coming off of a private driveway. Again, it doesn't have to be a private driveway. It could be a county road. You know, we got a case that's supposed to come up. It's been continued about 2 or 3 times down in southeastern Kentucky, where the state's getting sued because of water coming off over the road. And they said that there was hydroplaning involved. That's their allegation. Of course, the tires on this particular car were bad shape. That's one issue we got. But when that one's kind of like this case, because the case I'm talking about, the other one is where we've got a county road, a paved county road, coming with a steep grade down onto the state road. So we have a lot of situations where we have water draining off either a private property or some other kind of road and back onto our road, like we have here. This is an extreme example of it. So what can you do here? Well, you could try to get an easement and go back and drain better as far as water getting off that driveway into the ditch. You could put a grate across the ditch. Of course, to clog up with gravel. You could pave part of that driveway and put a grate. Several things you could try to do, but that is a real life problem. It's a result of a big issue. And this is not what you want, that's for sure. Part of risk management, we get into more detail in our whole day class, is where you look at different parts of the state and what districts, what counties are having the highest number of claims. As would be expected, Jefferson County, Louisville has by far a huge number of claims, by far the highest number, and Robinson County, our lowest population, has way small number of claims. That's just total claims. But if you look at amount paid, while Jefferson County is at the top, what we've seen a lot of is some of our southeastern Kentucky counties, like where we see Pike, Harlan, and Knox are all the next 3 in the list. And they certainly aren't necessarily our highest populated counties. But we've had a lot of cases in that part of the state where we've had issues with drainage. We used to have a lot more coal truck traffic than we do now, but we still have a lot of heavy truck traffic, and we have ruts, and the ruts fill up with water, and we have hydroplaning. We have all sorts of issues related to that area. So part of risk management is to understand why you're being sued. If you're a big agency, what parts of our area, geographical area, are getting sued for what reason, and just try to address that. We try to be proactive rather than reactive in preventing the lawsuit. And again, the purpose of this when I teach this whole one-day risk management class, and I say it over and over again, is we want to minimize our risk, our exposure, minimize number of lawsuits. But the best way of minimizing lawsuits is to not get sued to start with. So what we try to do is understand why we're sued, why people think we did something wrong, and identify that before it happens. If we don't have an accident, we're not going to have a lawsuit. To give an example of a couple of cases here, where we talk about to show you how hearing officer works. If it's a state case that goes through Board of Claims, it's a hearing officer that decides. They can appeal it past the judges past that, but it's a hearing officer. If it's a county or city, it will be a regular old jury. But here, just to show you the ruling and some of the concepts that are the same no matter what the case is. This is a case we had down just south of Bowling Green, where late one night it was raining, and these husband followed by his wife was driving down on a motorcycle. They wanted to pull over. The husband pulled over in this area to the right, where this black car is parked, and his wife comes along later. It's nighttime, and what does she hit? She runs into, and I took a photograph there at night showing it. Doesn't do justice, but that island, she runs into that channelized island, hits it as a wreck, some serious injuries. So they sue the state, say, well, you put it there, you put an object, a hazard, and didn't mark it. Now, so we got a big debate on whether or not it was reflective or not, or how reflective it was. There were beads on it. Show there were beads on it. I say it was painted in beads, and you could see it at night. Their expert said you couldn't. So we go back and forth about that. But this is what I want to show is what the recommended order was, to show you the general concepts that we get into here. First, they always say the cabinet, whether it's the cabinet, the city account, whoever it is, you have a duty to maintain roads in a reasonable and safe condition, which we don't argue. That's exactly right. And they also say once the cabinet or whoever it is aware of a problem, it's your duty to take a reasonable action to correct that problem. And we don't argue with that. The next one is, well, it's debatable. After you get notice, and we'll talk about notice in a minute, can you be held liable or not? There's different kinds of notice. And the issue is, after you get notice, or you didn't negligent, if you don't do something about it, yes, you are, you can be. But we had no notice here. That was part of this deal on this one, the issue of notice. There was no evidence. We were aware of any problem. I said it was reflective. You could see it. Their expert said that you couldn't see it. They believed what we thought, and they denied in this one. And they got, because they say we did not breach our duty of care. And that's kind of the steps that we go through. In this case, a hearing officer or a jury should go through the same steps also. Another example. And if you go to my one-day class, you'll see a few hundred of these, but I'll just give you a few of them. This guy's driving down the road, and all of a sudden he hears a big clunk of his mirror, stops, and his mirror had sideswiped the pedestrian, so we had a fatal crash. And they sued the state because of these high weeds, saying that the pedestrian couldn't walk had to walk out in the road because he couldn't get off the road because of the weeds, which again is and they also said that they couldn't see the headlights coming because of the weeds, but I don't think it's the case either. So I thought in this case that there was no breach of standard of care, because how often do we mow our weeds on our state roads? We have either 2 cycle or 3 cycle a year. You didn't like you're mowing your yard. You don't mow it every week. You can't. That's not reasonable expectation. The contract had already been let to mow the side of the road by a contractor. This was done by contractor. And they had started in this district. They had not started at this location. They started at another place. So I thought there was zero exposure, and obviously, as you see here, the judge didn't think so, because they said that, we said that it was the contractor had started the mow, but they hadn't started the mow there. Well, the issue we got into was, and I want to mention this as far as I don't know how many people have given depositions, but one very important thing, the most important thing I'll tell you about giving a deposition is they ask you the question, you answer the question, and then you stop. You don't keep talking, because if you keep talking, we might have big problems. In this case, they asked one of the state people who was involved in the contract. He said, well, we could have told them to mow there first. So that's what they say. We had discretion. They could have told them to mow there first. You should have told them to mow there first. Well, that argument was why. If you look at our standard of care as far as mowing, and where we would tell anybody, if you have 500 miles of road to mow. Where are you going to go first? Well, you go places where there might be a problem, where you might know there's a lot of pedestrians, where you got line of sight problems coming from an intersection, all that kind of thing. But this really wasn't a dangerous situation that I thought at all. There should have been exposure, but again, we found a certain percentage at fault, and that was the judgment against us. Of all the hundreds of cases that I've been involved in with Board of Claims, this is up there with the one that still I have issues with the finding here. This is state road, looks like a county road. It could be a county road, but it's a low volume road. The whole issue here becomes what the advisory speed should be. Did we breach our standard of care and have the wrong advisory speed? It's 25. It's still 25 because that's right. Their experts said it's supposed to be 15, which is wrong. It wasn't. But the guy was going way too fast around the curve, off the curve, and left a couple hundred feet of skid marks into a tree, fatal crash. So he was going way too fast. They couldn't argue about that. But the whole issue became the advisory speed. Did we do the advisory speed the correct way? And I won't get into it in depth. We have a whole class, one day class on how to set advisory speed for curves. But here are the ball bank readings. This is the way you do it. This is a recognized way of doing it. If you look at the data here, it tells you that the advisory speed is supposed to be 25. We did it the ball bank method. We had another method we're using with called a computerized version. I did that as part of a research project. I used it on this road too. It came up with the same thing, 25. 25 was right. Still right, still 25. But a big question became, did we have a lot of accidents there? We looked at the crash data. We found no other accidents there. Their plaintiff expert argued that, well, the farmer that lives there said he had seen a bunch of accidents. He'd pulled some people out of his field, but they weren't accident reports. So the hearing officer said, well, your database wasn't good enough. And it said the MUTCD really wasn't good enough, which is not a good ruling, not a proper ruling. I didn't think the ball bank method didn't give you the proper number, and it did, but it still didn't matter because even though they believed that he was speeding, which he did, he was, found the state in this case 50% fault, and they got $200,000, which was at the time the maximum they could get. So, yeah, usually hearing officers, you think. Use proper judgment. In this case, I don't think he did. But in my private business, I've testified in a few hundred trials, not as many here lately, although last few years, although I've got several going this year, and they're catching up with the pandemic, because you never can tell what a jury is going to do. And sometimes you can't tell what a hearing officer is going to do. One of the most important things that I go over, and I want to talk to you about as far as definitions, we talked about standard of care, which is very important. We're going to talk about notice, but we're going to talk about the whole issue about comparative negligence versus contributory negligence. And as I showed you in this last one right here, the claimant was 50% at fault, but he still got $200,000 because he had a huge amount of damages. 50% times that damages was over $200,000, which was the maximum. So what they do in comparative negligence is that you've got 100% total. We found if they're suing you as a individual or you as a state, city, or county, they find you a certain percentage at fault. And in Kentucky, it's pure comparative. We got the worst state for defense, the best state for plaintiff. Most of the states around us, in fact, all the states around us, I think, you have to be more than 50% found, more than 50% at fault before you can get a judgment. In Kentucky, you can be 1% at fault, any percent at fault, and they're going to multiply that percentage times the damages, and that's how much you're liable. So if you're 10% at fault and they can prove $2 million worth of damages, you're going to pay $200,000. Just because the plaintiff is drunk, just because the plaintiff is going 30 miles an hour with speed limit, just because it's on a cell phone, all those together. If you did anything, just because he did all those, if you're any percent, you're still going to pay. As opposed to what it used to be many decades ago, it's contributory. That means if you contribute to it, you can't collect, but it's not that anymore. We got pure comparative negligence. You need to understand that. You just can't say, well, That guy was drunk. This is his fault. We don't have any responsibility for it. That guy was going way too fast and ran off the road in this curve just because we didn't have a curve sign. He was going too fast. No. If they find any percent, that percent you pay. Very important thing to understand. Another important concept to understand is the issue about notice. I've talked about that somewhat. When I get in any of these cases, one of the first things I wanted to understand is, did we have notice of this? Was there previous accidents? Did we have documented people calling in saying, I was complaining about this? And that's what you have. You can have actual notice. That is, somebody called in, and called in your maintenance bar and said, I got this sign down for them. So, but you need a document when they do that, because what we get into is, say there's a curve sign down. And the question is, how long was it down? Well, you might say, well, I didn't know anything about it, to be in the state. Well, they'll say, well, I called in and told you that. Well, they say they did, you say they didn't. If you have good records, every time anybody calls in, this is our complaint log. So we got documentation. It wasn't on our log, therefore you didn't know about it as far as actually been told about it. Now, we also have something called constructive notice. That means, after this word again, reasonable, after a reasonable amount of time, you should be aware of this defect. I don't care if anybody told you about it or not. So the question is, how long is a reasonable amount of time? And that's what we argue back and forth. How long should a curve sign be down before you know about it? I don't know what the answer is. I mean, it's certainly not several months, but it's not exactly 2 days. So somewhere in there. So constructive notice is, what is this reasonable amount of time? What kind of inspections? And here we get into, what's our standard of care about inspections? We out there looking at our roads. Is there anything that says we're supposed to drive our roads every day, every week? I don't think it is. If it is, then we have to do exactly that. So the question is, what's a reasonable amount of time? And the question I had before, we had about exposure of the employee. I think that's when I think the answer to that is back here when I talked about comparative versus contributory negligence. And when I'll talk about here in a minute about ministerial versus discretionary duties. So there's a different kind of notice we got. An example of a case, this is the case down South Central Kentucky where we had, on the right here is a funeral home, and we have a mid-block crosswalk and a two-way left turn lane. So late one night, pouring down rain, and this is a pedestrian warning sign, which was not up. It had been down for a long period of time. The guy comes up and stops this two-way left turn lane, and his wife and her elderly father goes across the road. These teenage girls going to a football game, driving in the direction we're staying here, says that they saw the car stop, saw a woman come out and go across, and then they kept on going, and all of a sudden, the elderly gentleman was in their windshield. So we had a fatal crash. They sued the state because this sign had been down for a good period of time. So this goes all the way to the hearing officer, and I'm defending the state. So what's their defense here? My only testimony I could say is that this sign warns you of what? There's pedestrians in the area. The testimony of the driver was they saw the car stop, they saw a pedestrian get out and walk across the road. So my argument was, even though the sign was down, that was not the proximate cause of the accident, because it just tells you there's pedestrians and they already saw pedestrians. So what more is the sign going to add? That was the logic, the only logic I had to try to defend that case. The hearing officer said he's correct. We didn't maintain our sign. Been missing for a few weeks, some period of time. So we had constructive knowledge of it. I couldn't argue any of that. It was wrong. My argument was it didn't matter because they saw the pedestrian anyway, and it didn't add anything to what the driver would have seen, would have known about. But I would argue that the pedestrian had no responsibility, because if I see, even though you got right away in a mid-block crosswalk, if I see a car coming with headlights and they're not stopping, I don't think I'm going to walk out in front of it. But they gave this award, which isn't, it's enough, but That's where we get into with the limited exposure, because this is an elderly person who did not have a lot of damages, and they couldn't have pain and suffering. They couldn't have a lot of things that another wasn't a case against the state that they could have gotten. So that's how much they got in that case. Again, that's the question I had before about the immunity of the individual person. I think here's my answer to that is this: is discretionary versus ministerial acts. If what you did, you can show as discretionary act, that you had a choice and you use your judgment, then you have, I believe, this immunity. If what you did was violate what they say you didn't do or did do, violated a quote ministerial act, which doesn't require judgment. There's something in your standard of care that says you shall do this, and you didn't do that, then we got problems. There's where I get into this issue about documentation. An example I gave with a stop sign on the opposite side of the road. With a manual, it can't be there, but not putting it on the right side of the road, the correct, because the manual says it shall be on the right side of the road. But if there's no place to put it, and you put it on the left side of the road and do all these other devices to make signs and markings to make sure anybody has a reasonable opportunity to stop, you might have deviated from what the quote typical standard of care, which they could say is ministerial act, but you documented why you did it, and it was reasonable why you did it. If you don't document it, then we got big problems as far as exposure. But the biggest words, the biggest concept I could talk about today when we talk about personal liability is discretionary acts versus ministerial acts. Discretionary is where you have judgment. Ministerial, obedience to instructions. And we'll argue this, and I've argued it many times when I've been defending individual people. That's what I said was this: you did what you did or didn't do was discretionary. The plaintiff expert's going to say, no, it wasn't. You violated your duty. Here's a great example of discretionary act and how that played into an accident. This is on New Circle Road. This person late to school, taking his kid to school, lost control. There's the tire tracks across the road, head-on collision coming the other way, as you might expect, a fatal crash. And afterwards, it was already in the process of being let. We now have a cable barrier. They said that we violated our duty by not having this cable barrier there. And I won't go into big details because we don't have a lot of time to get into it. But I'll just say that we'd put this at other places before we put it here because it was originally approved for a certain slope. And this slope was steeper than that slope. When it was approved for the slope on New Circle Road of our median, then we left the contract. That's discretion. And so the recommended order, and this went all the way, they had their expert said that we violated all this stuff. And I said, no, we didn't. Hearing officer, this was his decision. We used this decision-making process that was discretionary. You know, there was no law that required this particular type of median. This was a judgment call, a policy-making call, and the claim was dismissed because this is a discretionary decision. If anybody, we have people here from the state and other agencies, but again, I see more and more people getting sued. I know from the state that I guess your city or county, whatever the case may be, they'll provide a attorney to represent you. And in the cases I've been involved in, whenever I thought there was an issue, there's some cases that's been settled. But it's a question about whether or not, if there ever goes to a jury trial and there is a judgment, we'll have to see what happens there. It had never happened ever yet. I don't want to be there when it happens the first time, because the question is, could the government pay a judgment that is a jury judgment against the individual person? Again, they've settled cases. I know that for a fact. I'll show you a couple of examples, but we haven't got to the point where they've had to cross that bridge about a judgment. And I'll close the day by showing a couple of examples where individual people got sued and they end up paying a settlement. This was the case of Jefferson County where we built this new bridge, and at the end of the bridge, you've heard about the bump at the end of the bridge. We had a big bump. It just continuously was a bump here, because what you're supposed to do is at the end of this bridge, you put in layers. You put on a layer, you compact it, you take a density test, then you put another layer, and you keep doing that, making sure it's dense and it's not going to settle. This kept settling. We had an off-duty policeman coming down here, riding this motorcycle, going way too fast. And his first cone is where he hit the end of the bridge. That first tree you see up there on the right, that little cone up there, he hit that tree. That's where he was injured. And the motorcycle kept going, and the motorcycle ended up at that curve up there. So we had issues of speed. The problem we had here was this kept settling. We patched it with settle, patch, over and over again. And we come to find out there's just a muffler that got knocked off as he bottomed out there, knocked the muffler off because of our bump difference in elevation. So come to find out, we didn't do density tests. And afterwards, it was told, well, when I talked to the people, I said, well, we didn't do the density test because it had too much rock in the fill. We couldn't do the density test. Well, our standard of care says the engineer will check density according to Kentucky method so-and-so. So is that a discretionary word, or is that a ministerial word? There's a big argument about that. The other one was we didn't do it because we had a reason. We didn't document that reason. Nowhere in our daily diaries did we say, this is what we didn't do because of this. So if we'd had that documentation, we'd have been a lot better off. In this case, got settled. Another example, this is a 275 up in northern Kentucky, where we were widening the road. At the time the accident happened, this concrete shoulder was being used as a travel lane. And there was the edge of our concrete shoulder. And we have a classic shoulder drop off, the worst kind of shoulder drop off you can have, straight up and down. And there is the best photograph I've ever seen of our scrubbing on our shoulder drop off. So this double trailer gets off there. The CDL driver should know a lot better. But anyway, overcorrected into the meeting. He goes, they sue everybody in sight because of fatality. It took a couple of workers, but they ended up suing some individual people because we should have known about this drop off. Well, this case was actually investigated by National Transportation Safety Board. And the problem we had here, we had all these other crashes and we didn't know anything about it. We were supposed to know about it, but we didn't know about it. So as part of this, I think I'm about to run out of time. I'm going to finish up here with one other thing, is that we now have this particular form we developed as one of our research projects. And hopefully the state has this version or some other versions. The point I would make is if you're in a construction zone, document what's going on. You need to understand what's going on. I'm involved in another case real quickly down in far western Kentucky right now, where we've had 3 fatal crashes in about 2 months in this work zone. About truckers running in the back of the queue of traffic. We've had 40-something crashes in about 5 months. Big issue. We got signs on top of signs on top of signs. We need to document what's going on, so later on we can show we had the proper traffic control. This is what I looked at the aftermath after this particular case this location was repaired. We had a situation where the car got off the road because of a distraction of the driver, runs and hits this end treatment. There is the end treatment that I looked at the time. It was replaced exactly like it was when the accident happened. We have an accident involving that. The guardrail goes right through the car, fatal crash. And we go back and put the same guardrail back. So I'll mention this, is if you have an accident and it looks like that, don't replace it just like you had it before. And when I went back out there later, after telling them that's what they replaced it with, the quote standard guardrail. So we had a lot of accidents involving guardrails. Just because it's not a standard guardrail at the time, you can't go out there and keep replacing them every time the guardrail end treatment standards change. But if you have an accident involving that guardrail, you need to replace it with a standard guardrail that exists at the time. Another point I want to make. So we're supposed to go to 10 and it's about a minute till. So that's pretty good timing. Anybody have any questions about this real brief overview of risk management? I could go with war stories one after the other, because I've got a ton of cases going on right now that I could talk to you about. But I'm trying just to touch base with some the various concepts you need to understand. Some of the most important ones I want to mention again is discretionary versus ministerial duties. That's where your personal immunity comes into play. The issue about the fact that Kentucky has pure comparative negligence, issue of notice. Those are some of the words that we would get into over and over again.